Hi there, thank you so much for signing up to attend this webinar session, which is part of the King's Young Professionals series. Though I must stress that this is open to all professionals, whether young or young at heart. Later on in this presentation, there will certainly be a test that will weed out the really young from those who can still remember Blockbuster, the video store. But today we're here to consider the issue of strikeout in the Employment Tribunal. And the reason why I chose to speak about this topic is there's been an awful lot of activity recently in the EAT on strikeout applications. And so what I'm going to do today is take us on a quick run through the rules, the basic structure that we'll be familiar with for strikeout applications, and then talk about those new cases we've seen from the EAT and what principles they remind us of from the case law we'll be familiar with and what new applications we can learn from. And in that sense, I think that there are insights for both claimants and respondents in terms of making and responding to strikeout applications. So without further ado, we will be familiar with the rules on strikeout applications, and those haven't changed substantively in the latest version of the Employment Tribunal rules. But of course, the numbering has changed. So I'm only going to refer to the latest numbering because otherwise we'll all get confused with references to the previous numbering. But the numbering we're familiar with is Rule 38. There are 5 grounds on which a tribunal can, on its own initiative or the application of a party, strike out all or part of a claim, response, or reply. And those 5 grounds we'll go through in more detail as this webinar progresses. But really, with respect to Rule 38, the rule I'd particularly like to draw your attention to is 38.2, about a party having a reasonable opportunity to make representations in response to that strikeout application, because that's something we've seen a lot of recent activity from the EAT about. Rule 38.3 and 38.4 reply primarily to responses or replies being struck out, and while I will refer to those briefly later on in this webinar, they tend to be less common. The strikeout applications we mainly see are for claims to be struck out rather than responses or replies, but that's not to say that it never happens. Oftentimes when we think about the rules of striking out, people go to Rule 38 and stay there, but I think that's a mistake, because while we often consider or occasionally consider strikeout applications in the context of a final hearing, that is fairly unusual, and most of the time strikeout applications are considered at a preliminary stage. And so the best thing I think to do is to go to the rules on preliminary hearings, which start at Rule 52. Rule 52.1 is really helpful and I think probably underrated because it talks about all of the different things that can happen at a preliminary hearing. And this is a good thing for both claimants and respondents to bear in mind about what can potentially happen at a preliminary hearing, what scope there is to shape a preliminary hearing in your side's favour using some of those different tools in the toolbox. Rule 53 and 54 are important. Rule 53 reminds us that the tribunal can direct its own preliminary hearing, which it will do in most claims, but the parties can also apply for a preliminary hearing. And so when you're making those applications for strikeout, it is worth applying for a preliminary hearing to consider that application. And that's for 2 reasons. Firstly, the side responding has to be given reasonable notice of the date for the preliminary hearing, and they have to be given reasonable notice of the strikeout application. And strikeout applications, as well as preliminary issues, have to be held in public. So the default for a preliminary hearing, when that is listed automatically by the tribunal, for example, upon receipt of an ET3, is that preliminary hearing will normally be held in private as a first preliminary hearing. But if you want that preliminary hearing to be held in public, you have to tell the tribunal that. And so it's helpful when you are making an application for strikeout or for a preliminary issue to be considered that you write into the tribunal and you make it explicit that you want a public preliminary hearing to be held to determine either the strikeout application on the specific grounds or a preliminary issue. That solves 2 things. Firstly, it gives the tribunal time to convert it, and it gives the tribunal enough time to give notice of what's going to be considered at the preliminary hearing to usually the claimant, And this solves the issue of having to have a private preliminary hearing to then schedule a later public preliminary hearing to hear an application that you already know that you want to make. It's a shortcut, but you have to make that explicit application in most cases for a public preliminary hearing to determine the specific issue that you want to be determined. And it's for that reason that I would always encourage solicitors drafting ET3s in particular not to make the application for a strikeout or the application for consideration of a preliminary issue within the ET3 itself, but to make it separately as a separate application to the tribunal. Firstly, it's less likely to get missed by tribunal staff who may not be reading ET3s with a fine-tooth comb, but also it flags that need to have a public preliminary hearing and to have sufficient notice, both in terms of time and in terms of what the content of the application is going to be. So what is reasonable notice? Reasonable notice is something that's been considered quite a lot in the most recent case law from the EAT. The kind of historic case that is frequently cited is Hassan and Tesco. And what that case involved was a strikeout application on the basis that a claim had no reasonable prospect of success. And there had been essentially all of the claim was struck out at the preliminary hearing, and that was held to be in error. But half of it was okay and half of it wasn't okay. And so there was no notice given for the strikeout of the discrimination claims or claims for other payments. And basically the tribunal, the EAT, said that's procedurally unfair in the extreme, that on the morning of the day, the judge in that case raised that they were going to strike out the discrimination and claims for other payments because there hadn't been sufficient notice for the unrepresented claimant, for whom English was not their first language. It was, however, okay to strike out the other claims for whistleblowing detriment, unfair dismissal, and some claims relating to intellectual property, which of course aren't within the jurisdiction of the ET, because the claimant had been given 11 days clear notice of the possibility of those claims being struck out at the preliminary hearing. So what we learn from Hassan is you can't just say, well, we've given notice we're going to strike out some things, so that's enough to strike out other things too. That doesn't work. And what Hassan says is that just some notice on the morning of the day itself isn't sufficient. You have to give sufficient notice in advance. In terms of the recent EAT cases, these series of 3 2024 cases, the Edinburgh case is essentially a close analogue of Hassan. Some cases referred to in the notice of hearing as being up for a strikeout, but not all, and then other claims were struck out on the day. The claimant wasn't ready to deal with strikeout of those other claims that hadn't been raised in advance. Her lack of preparation was entirely reasonable, and therefore it wasn't proper to strike those claims out because there wasn't reasonable notice given to the claimant. Staffordshire City Council is a different case. So that involved an application for strikeout of the respondent's defence. And basically there were issues with inactivity by the respondent's representatives. The tribunal, the EAT, described it as multiple breaches of tribunal directions, purported compliance or activity shortly before preliminary hearings. There were 7 preliminary hearings in this case, and the response was struck out at the 7th preliminary hearing. The defence and grounds of resistance were entirely struck out at that 7th preliminary hearing because the judge decided a fair hearing was no longer possible and it was proportionate to strike out the defence, which is an unusual step. And what happened in that case was that a fairly senior solicitor at a law firm had covered the hearing, but having been familiar with the file, most of the strikeout application in the end ended up being about late disclosure, although there'd been previous descriptions of the basis for the strikeout application. Most significantly, the respondent's rep didn't make any request himself for an adjournment to deal with the strikeout application. And the EAT concluded that a reasonable opportunity amounts to having an adequate chance and not merely the possibility of speaking at a hearing. Whether an opportunity is reasonable will be intensely fact-specific. And there, the experienced legal representative had attended a hearing. He was a senior member of the firm with responsibility for the disclosure exercise. He had indeed addressed his mind that a disclosure issue, and he'd accepted that the disclosure issue was likely to be raised. Therefore, even though the solicitor dealing with the matter didn't have a great deal of prior knowledge of the case and was dealing at short notice with the case and the hearing, he was expected essentially to be able to respond to the strikeout application, and therefore he was in fact given reasonable notice. OBSC and Hyde Housing is an interesting case because there essentially the strikeout app was successful on the basis that the claimant's representative had conducted himself unreasonably. But there had been a very short window in which the claimant and her representative had been given time to respond to a strikeout application at the hearing itself on the basis of the representative's conduct. And as part of the kind of logistics of the tribunal liaising with the claimant and her representative, the tribunal hadn't told the claimant and her representative the basis upon which the strikeout application was being made, i.e. the representative's conduct. And the tribunal said essentially the claimant should have been given an opportunity to understand what the basis of the application was, because she should have been given an opportunity to consider whether she still wanted to be represented by the person who did in fact represent her. So it's important that where a representative's conduct is the basis for the strikeout application, that the claimant themselves is given reasonable notice of the application and therefore an opportunity to respond. So turning now to those 5 different bases on which claims can be struck out. These I know will be familiar to many of you. The first that we're going to consider is the conduct issue. I'm going to come back to the second half of 38(1)(a), reasonable prospects of success, later on, because I think that is of a slightly different nature, a slightly different character than the rest of 38(1)(a) and B, which come down to either the claim itself being scandalous or vexatious, or as we more commonly see, the notion that the manner in which proceedings have been conducted by or on behalf of, typically, to be honest, the claimant. Although as we've seen in that previous case, sometimes the respondent's representatives has been scandalous, unreasonable, or vexatious. In terms of 38(1)(a), to be honest with you, it's very unusual that we see a claim being struck out on the basis that the pure claim itself is scandalous or vexatious, although that's not to say that it doesn't happen. It does occasionally happen in the case of cases that are seen to be severely vexatious. But to be honest with you, most of the time we're looking at 38(1)(b, and certainly that's what most of the case law looks at. In terms of the case law, these cases I would say are the biggies that representatives should be familiar with. I'm going to go through the first 3 just in terms of the main headlines because they're referenced so often. Those are cases that everyone should know. But really, Imumikoro and Carr and Sunmark are important to be aware of as the latest statement of the position. In particular, Imumikoro talks about a fair trial being possible within the trial hearing window, which is particularly important. Our nominees is a really important case on strikeout because it comes up in almost every context to consider whether tribunals should exercise their discretion to strike out. So it's very clear the function of the court is to do justice between the parties. A fair trial is one conducted without undue expenditure of time and money, with a proper regard to the demands of other litigants upon the finite resources of the court. This is even more important than it previously has been because of the degree to which employment tribunals are stretched, bluntly. And we know that delays in employment tribunal claims, particularly for longer hearings, means that a final hearing being lost can cause months, if not years, of delay. And therefore, considering the impact on the tribunal system as a whole and on other parties of misconduct is really important. And finally, decisions to strike out aren't about a desire or a perceived need to punish. They're about a proper and necessary response when a party is shown that their object is not to have a fair trial. Balch and Shipman, again, is one of those big 3 that everybody needs to know. Sometimes people, and including in the EAT judges, summarise Balch and Shipman as a 3-step approach, but actually if you go back and read paragraph 55 of Balch and Shipman, there are actually 4 questions. And the mistake that was made in that case that we were looking at earlier involving Staffordshire County Council, where the defence was struck out, was actually that the fourth question in Bolt hadn't been considered, i.e. what the appropriate consequence was for the defaulting party, because where a defence is struck out, and therefore a claimant succeeds on liability, there's a question about whether the respondent should still be allowed to participate in a remedy hearing or not, and that hadn't been properly considered as part of step 4 of Bolt. So don't miss all 4 steps of Bolt if you're dealing with a section 38(1)(b) claim. Remember it is still in there. The third big case to be aware of, and this is a test of the decade in which you were born, is Blockbuster and James, which always makes me think of the video rental store where we used to rent videotapes, and I will show my age there, and that will test, I guess, in this seminar who's really a young professional and who's not. But Blockbuster and James, again, is referenced in almost every case, and I think actually in some of these cases we lose, because we're so familiar with them, the facts of them. So what actually happened in Blockbuster was that the litigant attended the tribunal for the final hearing with 50 or 60 pages of documents, which he sought to rely on that hadn't been shared with the respondent, and an audio tape of an alleged incident in the workplace that he wanted to play at the hearing. And that tape hadn't been disclosed to the respondent. So far, so familiar. There was also a dispute about whether the claimant had complied with various case management orders. Again, so far, so familiar. And in that case, the Court of Appeal held that the decision to strike out on the basis of conduct, the way that the hearing had been conducted, was unreasonable, because in that case, a fair trial wasn't impossible, and the tribunal had to consider the proportionality of the response. There are these other comments made in Blockbuster, which are cited in many cases, the first object being to get tribal cases tried, how unusual it is to strike out cases when they've got to the point of final hearing. And finally, in terms of proportionality, having to consider whether there's a last drastic means to the end for which the strikeout power exists. Strikeout is essentially always, because that proportionality question will always be considered the last resort. And as the person making the strikeout application, it is incumbent upon you to always address that question about why nothing lesser is possible. And the vast majority of strikeout applications fail because the respondent is not able to demonstrate why a lesser sanction is not possible, because in most cases, some sort of lesser sanction will indeed be possible. So yeah, that is a brief rattle through those top 3 cases on conduct issues, just because they are so frequently referenced in the other case law dealing with the other potential 38(1) heads of striking out claims, but it is also worth reviewing in Numicoro and Carr on your bedtime reading list, particularly if you're dealing with a conduct issue. The third basis on which you can strike out non-compliance with rules or with tribunal orders. The approach to be taken in 38(1)(c) cases is the case in Blockbuster. Firstly, the tribunal has to determine whether the threshold has been reached, i.e., whether there has been non-compliance with rules or orders. And secondly, whether the tribunal is going to exercise its discretion. And when it's considering that discretion, proportionality, whether some sort of lesser sanction is permissible to allow a fair trial to go ahead, will always be considered. Just in terms of top tips, if you are applying to strike out on the basis of non-compliance with rules or orders, a really clear timeline about compliance, what steps have been taken to ensure compliance, is really important for the tribunal to have, and that will be a vital ingredient of your application. 38(1)(d), striking out on the grounds that a claim has not been actively pursued. There is recent helpful case law on 38(1)(c) and (d). Camfu's the 2025 case is interesting because that is a case where the tribunal essentially forgot to exercise its discretion. It established that there had indeed been breaches of orders, but it didn't consider that question of whether it should exercise its discretion to strike out, having regard to all relevant factors, including whether a fair trial was still possible. So in that case, the EAT found that actually the tribunal had just missed the step. It found that there had been a breach, but it didn't then go on to consider its discretion. And that was contrasted with the decision in Smith and Tesco, which similarly considered whether the tribunal should exercise the power to strike out, but in that case did actually go through the whole discretionary process and considered in that case there was no lesser sanction and a fair trial was no longer possible, essentially because the claimant in that case was no longer willing to comply with the tribunal and abide by tribunal orders. That second step hadn't taken place in Campus. So in Carver, the tribunal considers the overlap between a failure to comply with case management orders and a failure to actively pursue. And it talks about failure to actively pursue generally falling into one or two categories. Firstly, either a intentional and contumacious failure, or just merely conduct that's resulted in inordinate and inexcusable delay, giving rise to substantial risk that a fair trial is not possible, or serious prejudice to another party. And in that case, there was this pattern of failure of the claimant to comply with case management orders. But when the tribunal had sent the case management or the correspondence to the claimant warning that they were at risk of being struck out and asking if they were actively pursuing the case, the claimant did reply and say that they were. And so the EAT found that actually the decision to strike out had been taken likely without having seen that correspondence from the claimant, essentially writing in and saying that they were indeed still planning to continue with the case. So the caution there for respondents is that if the claimant does indeed engage, strikeout will often, because they're engaging, not necessarily be the proportionate step if other tools in the toolbox can be used to comply, get the claimant to comply with case management directions before you get to a Smith and Tesco situation where the claimant is just not willing to engage and comply with case management at all, such that further pursuit of the claim in a fair trial is no longer possible. On 1E, there's a separate ground where the tribunal can strike out on the basis that a fair hearing is no longer possible. And this has been considered in the case of Leaks and the case of McMahon, which are recent cases. And there's an interesting discussion at the start of Leaks about a fair trial not being possible as being a separate and distinct ground on which strikeout can be made. And the point that Leaks makes there is that there's no fault required in a 38(1)(e) strikeout. And therefore, unlike in 38(1)(b), (c) or (d), the tribunal doesn't have to find that there's been any sort of non-compliance or misconduct, but there may just be circumstances which render a fair hearing no longer possible. The classic situation is the Peixoto situation of illness. But that case of Leaks considered where a witness had been lost because they'd left the employer's employment. But in Leaks, it was held that wasn't enough, just the assertion that the employee who was alleged to have been involved in discriminatory conduct wasn't there, and the tribunal had to consider who is the witness, what evidence can they give, how long ago did the matter occur, has a witness statement been taken, either in draft or in final form, is the evidence supported by contemporaneous documentation, can other witnesses give evidence, is the employer still in contact with the witness, will the witness give evidence voluntarily, should a witness order be made? Is there any reason to believe that the witness is now disposed against the employer? So a whole range of questions, 10 questions that should be considered about a potential lost witness before deciding to strike out on the basis that that witness has indeed been lost. And those questions weren't appropriately considered in the case of Leaks. McMahon is a similar case. It's this very long case that involved allegations about events that had taken 12 or 13 years prior. And the court and the EAT accepted that, that would inevitably have some sort of impact on memory. But the problem in that case was that the particular discrimination claims that involved the historic events hadn't actually been particularised by the point that the strikeout application was considered. So what the EAT said is, before you're considering the extent to which evidence has been affected by the passage of time. You have to consider what is the case, who are the witnesses needed, what recollection of the events do the witnesses actually have, what are the contemporaneous documents. And in that case, those questions hadn't been considered, but also they hadn't done that work of clarifying the discrimination claim first before considering the strikeout. So a caution there that where memory might be affected, you have to have a very precise understanding of the way in which that memory has been impacted before you strike out. Plus, you need to consider whether the claims have actually been adequately particularised first. And finally, I promise we come back to it, 381A on no reasonable prospects of success. A reminder that applies to all or part of a claim. Sometimes all of a claim will have no reasonable prospects. Sometimes it might just be a part or specific aspect of the claim. The case law in this area will again be very well known to the tribunal. Those are the four biggies at least. Those four there that I'm sure many of you will be familiar with. Cox and Adecco is a really wonderfully written judgment that bears rereading. I put some of the relevant extracts on that slide, but really it provides a very good summary of the issues to be considered when striking out on the basis that a claim has no reasonable prospects of success. Of course, a similar approach in discrimination claims as in protected disclosure claims. There's no absolute bar, but the bar is very high, to put it bluntly. Cox and Adecco, of course, includes famous warnings about litigants in person when considering strikeout of claims. And it also talks about the tribunal, when it exercises discretion about whether or not to strike out, should consider the balance of justice in allowing an amendment if the amendment would essentially explain why the claim should be allowed to advance. So just because the pleaded case isn't enough on its own to avoid strikeout, if strikeout could be avoided with the amendment being made, you should consider whether the amendment should be made or not. Twist is also very helpful because it talks about there being cases in which factual allegations are demonstrably false in the light of incontrovertible evidence, and particularly documentary evidence. So where there is incontrovertible documentary evidence, that can be a basis on which to strike out either a discrimination or a protected disclosure claim. That being said, there have been quite a lot of recent issues with striking out protected disclosure detriment claims. Shea is an interesting case that involved a beauty counter worker at a department store. She brought direct discrimination claims and alleged that the something more was an anti-Chinese culture at the shop where she worked. And at first instance, the judge found that even if the instance she alleged as creating this anti-Chinese culture had actually happened, they wouldn't demonstrate an anti-Chinese culture. But what the EAT said was that's not the point. She doesn't have to prove an anti-Chinese culture. She just has to show that the burden of proof shifts for the purpose of the direct discrimination claim. So taking the case at the highest, i.e. all of the incidents which she alleges happened, that would be enough potentially to shift the burden of proof, and therefore the direct discrimination claim shouldn't be struck out. Similarly, in the recent case of Rainwood, the tribunal failed to consider whether an amendment would allow essentially the claims to surmount that threshold of no reasonable prospect of success. And in Kinch, the judge mistakenly thought that a fact was undisputed at a preliminary hearing when it wasn't. And actually an issue of whether the contract could be affirmed, had been affirmed or not by the claimant, could only be resolved by hearing oral evidence. So what are the tools in the toolbox? For both claimants and respondents, they should consider strikeout as one tool among many. And I think the problem for respondents is that often it's tempting to want to try to be harsh or come across strong and make a strikeout application straight off the bat. But that's often not the best thing to do because the bar for a strikeout, particularly in terms of prospects, is so high. So it's worth considering, for example, instead of striking something out, whether that deposit order, which has significant costs consequences should be made on the basis that something has little reasonable prospects of success, and particularly because a deposit order doesn't require the same sort of notice requirements that a strikeout application does, and the bar is lower. Similarly, if there have been issues with the claimant complying with case management orders, considering whether to make an unless order application, because if the claimant doesn't comply with the unless order, some or all of their claim will potentially be struck out. Finally, good old-fashioned case management orders. If you need more case management orders, writing in to request case management orders is always worth doing. Where a respondent is represented, the tribunal will expect, firstly, you to comply with case management orders, but also for you to help in terms of case managing the claim. In terms of tips for claimants, make sure that you determine which facts are actually in the disputed core. It's very easy for respondents to assert that some things aren't disputed or written evidence is incontrovertible when that isn't actually the case. So for a claimant being very clear about what the nature of the dispute is and where facts are in dispute. For example, some elements of discrimination claims, justification defences in particular, those are fact sensitive and require consideration of facts, and therefore it's inappropriate to strike out. So be careful as to what the respondent is saying can actually be determined without oral evidence. And similarly, if a strikeout application is made, taking advantage of that opportunity to put in sometimes written documents that explain where a dispute actually is. Finally, for claimants being aware that you must be given sufficient notice of applications. I think probably claimants are unwittingly bounced quite a lot into strikeout applications. So being aware of those notice requirements. All that remains to be said is thank you so much for dialing in and for joining this webinar. If you have any questions about anything raised in this webinar, please do get in touch with Brandon, my clerk, who I'm sure will be more than happy to help. So if there are anything arising, please do let us know and get in touch. Thanks so much. Have a good rest of your day.